In the previous section, we examined the legal implications of a purchase contract when only one spouse signs on behalf of community property, emphasizing Arizona's protection of marital property rights under ARS. Paragraph 25-14C. We now turn to another important instrument of property ownership in Arizona, the beneficiary deed, also known as a transfer on death deed. This unique legal tool allows property owners to plan for the transfer of real estate upon their death without the need for probate, while still maintaining full control of the property during their lifetime. The beneficiary deed is governed by ARS, paragraph 33-405, which was enacted to simplify estate planning and reduce the burden of probate court proceedings for heirs. It allows an owner of real property to name one or more beneficiaries who will automatically receive ownership of the property upon the owner's death. Until that time, the owner retains full ownership rights, including the right to sell, encumber, or revoke the deed at any time. Definition and purpose. A beneficiary deed is a revocable deed that transfers an owner's interest in real property to a designated person or entity upon the owner's death. Unlike a will, which must go through probate before assets are distributed, a beneficiary deed operates by operation of law, meaning title transfers automatically upon death once a certified copy of the death certificate is recorded. This process provides a cost-effective and efficient method of passing real estate to heirs while avoiding the delays and expenses of probate. Example: imagine Linda, a widowed homeowner in Mesa, wishes for her home to pass to her two children equally when she dies. Instead of creating a trust or relying solely on a will, she records a beneficiary deed naming her children as beneficiaries. Upon her death, her children record her death certificate with the county recorder, and ownership automatically transfers to them without court involvement. During her lifetime, Linda can sell or refinance the property freely, or even revoke the deed if she changes her mind. Legal requirements under Arizona law to be valid under ARS. Paragraph 33-405. A beneficiary deed must meet the following requirements. It must be executed and acknowledged by the property owners in the same manner as any other deed. It must be recorded in the county where the property is located before the owner's death. It must clearly identify the beneficiary or beneficiaries who will receive title upon the owner's death. It must state that the transfer is effective only upon death and that it does not affect the current owner's rights. If these requirements are met, the deed becomes effective immediately upon the owner's death, transferring title without the need for court intervention. If the deed is not recorded before the owner's death, it is void and has no effect. Rights retained by the owner. One of the key advantages of a beneficiary deed is that it allows the owner to maintain full control over their property during life. The owner may sell the property, refinance it, or revoke the deed altogether without notice to the beneficiary. The designated beneficiary has no legal or equitable interest in the property until the owner's death. For example, if Linda, from the earlier example, decides to sell her home before her death, the sale automatically revokes the beneficiary deed because title has changed hands. If she later buys another home and wishes the same beneficiaries to inherit, she must execute and record a new beneficiary deed for the new property. Effect on community property. When community property is involved, both spouses must sign the beneficiary deed for it to be valid. If only one spouse executes the deed, it will only transfer that spouse's 1/2 interest in the property upon their death. The surviving spouse retains their half interest, which could lead to joint ownership between the surviving spouse and the named beneficiary. For example, if Mark and Elena, a married couple, own a home in Gilbert as community property, and Mark records a beneficiary deed naming his son from a prior marriage as the beneficiary, only Mark's 1/2 interest will transfer to his son upon his death. Elena's half interest remains with her, resulting in tenancy in common between her and the son. This scenario can create complications for surviving spouses and underscores the importance of consulting legal counsel before executing a beneficiary deed for community property. Revocation and priority. A beneficiary deed can be revoked at any time by executing and recording a new beneficiary deed that explicitly revokes the previous one, or by recording a formal revocation instrument. Wills, trusts, or other estate documents cannot override a properly recorded beneficiary deed under ARS, paragraph 33, 405J. If a will and a beneficiary deed conflict, the beneficiary deed controls because it is a direct conveyance of title under state law. Practical use in estate planning. Beneficiary deeds have become popular among Arizona property owners as a simple estate planning tool. They allow property to transfer directly to heirs without probate while maintaining lifetime flexibility. They are especially beneficial for single individuals, elderly homeowners, or blended families seeking to ensure specific distributions of property. However, they are not always suitable for complex estates involving multiple properties, creditors, or tax considerations, where a trust may be more appropriate. Case example, Matter of Estate of McDonald, 2011. In this case, the Arizona Court of Appeals upheld the validity of a beneficiary deed that had been recorded years before the owner's death, confirming that the property automatically transferred to the named beneficiary upon death without probate. The court emphasized that because the deed had been properly executed and recorded under ARS para 33405, it could not be overridden by the decedent's will. This case reaffirmed the beneficiary deed as a valid, superior instrument for non-probate transfer of real property. Discussion. What is the primary benefit of a beneficiary deed compared to a will? Answer. A beneficiary deed allows property to transfer automatically upon the owner's death without probate, while a will requires court proceedings. Can a property owner revoke a beneficiary deed after it has been recorded? Answer. Yes. The owner may revoke it at any time by recording a new deed or a written revocation before death. If only one spouse signs a beneficiary deed for community property, what interest transfers upon that spouse's death? Answer. Only that spouse's 1/2 interest transfers, and the surviving spouse retains their half, creating a tenancy in common. Review summary. The beneficiary deed, authorized under ARS, paragraph 332-405, is a legal tool that enables real property to transfer automatically upon death to named beneficiaries without the need for probate. It preserves the owner's full control during life, including the ability to sell or revoke the deed. For community property, both spouses must sign for it to affect the entire property. If only one spouse signs, only their share transfers at death. Beneficiary deeds simplify estate planning, reduce costs, and provide a clear, efficient means of transferring ownership, provided they are executed and recorded properly before death. Real estate professionals should understand how beneficiary deeds function to guide clients in estate-related transactions and ensure compliance with Arizona's title and community property laws.